to another episode of Ask Jade. Today, I'm going to go over a fun little clause called force majeure. So you've maybe heard of this or seen it in other contracts, but I think it's pretty pertinent in the times we are living in. So force majeure is a French word that actually means superior force, but in the law, it is used a lot, and it means unforeseeable circumstances that prevent someone from fulfilling a contract. So, we've got past examples such as September 11th, natural disasters such as hurricanes, or more recently, COVID-19. So I would say all of those fall under unforeseeable circumstances that would prevent you from fulfilling a contract. So will you be able to cancel your meeting, your class, your performance without any penalties or fees or breach of contract? The key tool in managing risk in this circumstance is the force majeure clause. So this relieves parties from performing their contractual obligations when certain circumstances, such as the examples I just stated, are beyond their control. Sometimes these things arise and then they make performance inadvisable. They can make your performance illegal. Say we've got these stay-at-home orders, you're trying to fulfill a contract and now it's illegal or impossible. So without a force majeure clause, you are essentially left to the mercy of these narrow common law contract doctrines of impracticability and frustration of purpose, which rarely result in excuse of performance. So you don't want to be left to that. You want the assistance of an attorney, such as myself, to make sure that a force majeure clause is included in all of your contracts. So you want to have provisions in there that cover things such as natural disasters, such as hurricanes, floods, earthquakes, other weather kind of disturbances that are sometimes referred to as acts of God. Other covered events may include war, terrorism, threats of terrorism, civil disorder, labor strikes, disputes, fire, disease outbreaks such as pandemics, or acts of governmental authorities, etc. So courts tend to actually interpret these clauses pretty narrowly. For example, while acts of terrorism might be a specified event in your contract, it does not necessarily follow that a court would also excuse a party's performance based on threats of terrorism. So it's very important to specify any types of circumstances that you anticipate that might come up that would prevent you from performing your contractual obligations. And that's why it's important to get an attorney involved. Especially here in Illinois, the Illinois law, there's an implied duty that the party that's trying to be excused from their performance has to at least have had made an effort to attempt to resolve the event that is causing the delay or inability to perform before trying to invoke the force majeure clause. And this relates back to, a duty of good faith when entering into contracts. So, this coronavirus has had a significant impact on businesses and their ability to perform under their contracts. And a claiming party can successfully invoke a force majeure clause, but this is fact intensive and it's assessed on a case-by-case basis. So this is why you should always have a knowledgeable attorney in your corner to make sure you're covered when things such as coronavirus happen. As always, please feel free to reach out with any other questions and see you next time.